think we should start. So good afternoon or good morning, ladies and gentlemen. Welcome to our panel session dedicated to elevating legal services through regulation standards and dispute resolution. It's a privilege to moderate today's session discussion, which brings together leaders of our legal ecosystem, regulators, dispute resolution institutions, and practitioners to reflect on how high-quality legal services underpin the credibility of and growth of the AIFC. Since its launch, Astana International Financial Center positioned itself as an international financial hub with a unique legal framework based on common law. Alongside this, we have developed institutions like AFC Court and International Arbitration Center, as well as the regulatory regime for legal service providers and legal consultants through AFSA and AFC Legal Services Board. Together, these developments have been game changers in raising professional standards, ensuring quality and strengthening the investor confidence. The central premise of today's session is simply yet powerful. A well-regulated and professional legal community is the backbone of trust and efficiency in the AIFC, whether through regulatory oversight, courtroom advocacy, or day-to-day client services. Legal opinion, the quality of legal advice directly shapes the future of the AIFC law. To explore these themes, we are joined by our distinguished panel, Andrew Oldland, KC, a senior partner at Michelmores law firm based in London. Andrew also is a member of AIFC Legal Advisory Council, who advises on drafting and amending AFC law. Liya, Akzhanova, Chief Legal Officer of AFSA, who leads the regulatory function, ensuring that legal and financial services in the AIFC operate within a clear and reliable framework. Campbell-Holt, OBE, the CEO and Registrar of the AIFC Court and International Arbitration Center in the AIFC. Chris is also a member of the AIFC Legal Advisory Council, and he's also the member of the AIFC Legal Services Board. Chris has led the establishment and development of these institutions such as Court and Arbitration Center, guaranteeing access to justice and providing dispute resolutions to international standards. And Maxim, Burak, partner at Grata international law firm, one of the first ancillary service providers registered in the AIFC. Maxim is also a former member of the AIFC Legal Services Board. So Andrew, let me begin with you. As a member of Legal Advisory Council and a barrister with extensive international experience, why are professional standards and legal services regulations so critical for the credibility of an emerging jurisdiction of like the AIFC, and what lessons from global practice can guide on the development of future of AIFC law?
Thank you, Aida. I'm standing in for my friend and colleague, Simon Cox, who is the chairman of the Legal Services Board. And he wishes he could be here, but unfortunately he can't be here today. So I'm going to say a few words on his behalf. One of the themes that I suspect many of you would have picked up throughout AFD has been how important, from an investor perspective, the rule of law is. And I was at one of the plenary sessions yesterday where one of the vice presidents of Brookfield Asset Management, which has $1 trillion under its management, said there were three things that are absolutely critical for its decision-making as to where it invests: the respect for capital, the ability to scale up, and critically, the rule of law. And those are the type of decisions or criteria that will drive investment. As we all know, the AIFC has been set up as a common law system. The success of a common law system is critically important for the rule of law and the success of the IFC in general. But one of its features is, of course, that it has an adversarial court system. And the ability to deliver a successful common law system depends not only on the quality of the judicial decisions, but also, importantly, on the quality of the legal professionals preparing the submissions before the court. So competence in the common law system is absolutely critical to make the whole system work. But it extends beyond just competence, and I don't mean to belittle competence by saying just competence, to include, importantly, ethics and trust. The legal services regulations were introduced in 2022. Those regulations established the Legal Services Board. They introduced the concept of legal service providers. They required legal service providers to follow international best practice and also to provide support and training for lawyers within the AIFC. The requirements on the LSPs, those are the legal service providers, are as follows. They must act with independence and integrity. They must maintain proper standards of professional practice. They must act in the best interests of their client, not themselves. They owe a duty to the court to act with independence in the interests of justice, and they must keep their clients' affairs confidential. The guiding principles for the Legal Services Board include, there are a number of them, but they include the following: attempting to ensure the safety and soundness of the legal market within the AIFC, to act fairly, transparently, and in a non-discriminatory manner, to prevent damage, if necessary, by taking enforcement action, and to protect the interests of clients who are being represented in the centre. There are some base eligibility requirements which are supplemented by CPT, continuing professional development and in-firm training. But it's important to recognise that practising law in the AIFC is a privilege that has to be earned. It's not an automatic right. And those base level requirements will develop and strengthen, we anticipate, over the coming years. Building up expertise in the common law, especially getting a working knowledge of English law, is very useful potentially to many of you here who will be lawyers, because it allows you to work internationally more easily. So I commend it to you. The success of the AIFC as a young jurisdiction places a big responsibility on the lawyers and also those training them. And that's critical to bear in mind. And I should say, we have some very distinguished judges here. The Chief Justice is here and the head of the Arbitration Centre. I also sit as a judge. And I would just add this from a personal perspective, is that when you are attempting to judge sometimes some very difficult issues, the quality of the representations that are made to you by the lawyers is absolutely critical in helping you reach the right decision in a properly fair, transparent, and reasoned way. So everyone needs to work together to make the system work. That's the point that I'm trying to make. So in conclusion, I'd make 3 points. The AIFC legal framework has to be dynamic and responsive. We know there are constant changes happening now. There are more to come. We've heard a lot about AI, data governance, climate transition finance, and cross-border digital trade. On the LAC, with the help of the AIFC Legal Department, we are introducing new legislation on a regular basis to try and keep up. And you will also see a body of judicial precedent we anticipate developing over time to meet that challenge. Secondly, us lawyers, we've got to keep up, but also, I would suggest, specialise. So if you're looking at your practice areas, 3 examples where you might want to consider specialising if you haven't done so already: digital assets, Islamic finance, perhaps, ESG, and sustainable investment. And as you know, there is the Academy of Law here in Astana. And I'd say 3 words, really: training, training, training. Keeping yourself up to speed is absolutely critical. And finally, this as a general comment about the AIFC as a jurisdiction. It's geographically where East meets West, where emerging markets and developed markets increasingly are overlapping. And here, the need to meet both local and regional needs whilst ensuring international best practice is important. And provided that happens, in my view at least, I think the AIFC jurisdiction has a bright future ahead. Thank you.
Thank you, Andrew. Of course, legislation alone is not enough. It must be supported by strong regulatory oversight. That brings me to AFSA's role. Liya, AFSA oversees legal services providers. What challenges have you seen in ensuring that advisors consistently meet the required standards, and how does strong supervision in AFSA help protect AFC participants and maintain overall confidence in the system?
Oh, thank you, Aida. Thank you, colleagues, dear friends, dear ex-colleagues. I'm glad to be here to brief the market and the AFC community on the existing regulations on the legal services and ancillary service providers. The first of all, and the main point, that what AFSA does. AFSA regulates the legal service providers by means of first licensing, supervising, and enforcing when it is needed. Main important point, AFSA takes a risk-based approach during the supervision stage. What does it mean? In other words, it means that every action, every document, every transaction which is considered by the AFSA, it's considered from the risk point of view, like the risk has already been occurred or is to be occurred in the nearest futures. So Aida asked me about the challenges which legal service providers meet during their activity. I have outlined, based on our experience, 3 main points, 3 main challenges which legal service providers meet. The first one and the most common is confusing or mixing the acting law of the AFC with the mainland legislation. I will give practical cases as well. Practical case number 1, we received the Kazakhstan arbitration decision, which was adopted by the Kazakhstan Arbitration Center provided to the AFSA, and the decision was based on the law on the limited liability partnership, and it was related to the transfer of shares in the private company. Of course, such a decision and the registration, post-registration services didn't take place because the arbitration decision was based on the mainland legislation. The second challenge, which legal service providers often face, they disregard or ignore the onboarding procedures to their clients. They may forget to conduct a due diligence or risk assessment of their clients. Practical case as well. The legal service provider ignored or disregarded the requirement to QIC, to conduct the QIC and due diligence of its client, which led to giving false and misleading information to the AFSA. And of course, AFSA had to take an enforcement action, imposed a financial penalty to the legal service provider. The outcome, which the AFC participant received, he didn't, of course, complete its transaction. He misled and false the AFSA and received the financial penalty. The third challenge which we see from the legal service providers, this is weak legal advice which provided to the AFC participant. as Andrew said, that quality learn and train ongoing, which is required and also provided by the AFC ecosystem. AFSA expects that legal service providers, they are well qualified, they are best practitioners of the acting law of AFC. AFSA also expects that the documents, transactions, which goes under review of each legal service provider, they have been already reviewed and checked on the subject of its legitimacy, enforceability, and validity. So which sanctions can AFSA impose in case of any contravention which will be conducted by the legal service provider? The first and the most common, of course, is a financial penalty, which we can impose. The second, we can suspend or withdraw the license, which means you will not be able to conduct any activity within the AFC. We can withdraw the approved individual status within the company. We can issue a public censure in respect of the person, in respect of the contravention. AFSA can issue a private warning to a certain person. AFSA can also include the person or the company into the burden list. We can also request the company or the person to cease and desist from any activity. We can also restrict the company to hold the office or to being a director in a certain company. So which options we can recommend as a regulator to outcome the challenges? The first one is the permanent ongoing fit and proper test, which legal service providers should do. Train and increase the quality of your colleagues, of legal professionals within the AFC ecosystem, which is already offered by the Academy of Law. The third is to read and comply with internal policies which already been adopted as a part of obtaining the license within the AFC. So I personally encourage my colleagues, my friends, my ex-colleagues to be the best ambassadors of the acting law of the AFC. I always ask myself, if not us, then who? Thank you. So if you have any questions, please feel free.
Thank you, Liya. So when the regulation is in place, disagreement may still occur. That is where our next institutions play a vital role. So Chris, from your perspective, leading AFC Court and Arbitration Center, how do professional standards and the quality of legal representation translate into what you see in the hearings, and how does this impact both dispute resolution outcomes and international investor trust in the AIFC?
Thank you, Aida. May I start by just paying special attention to a notice of our Chief Justice, Lord Burnett, and of the Court, and our Chairman of the Arbitration Centre, Mr. Thomas Krummel, who's with us. You're actually sitting in the Court and Arbitration Centre Lecture Theatre right now, so welcome everybody to our premises. Very quickly, I wanted to mention also two other people, and that is Mr. Nurjan Kozbayev, who's sitting on the front row. Many people probably don't know that because so many years have gone past, but we've got Andrew, myself, and others who are representatives of the Legal Advisory Council, which has been created back in 2017, and more or less the same people are on that board. But it was Nurjan who created that on behalf of the AFC, and I remember sitting in a room with him on my first visit here in early January 2017, and Nurjan and other lawyers from the AFC at the table were saying, we've got to create an entire legal system for the AFC. What we're going to do. And it was remarkable, within 10 to 12 months, led by the absolute first-class international expertise of Mr. Michael Blair, King's Counsel, a barrister, distinguished barrister from Barristers' Chambers in London, and with Andrew, myself and others, we got there in a remarkably quick time. And now we're seeing, through the Court in particular, and some of the people in this room are seeing in the Court and in our arbitration centre, genuine day-to-day application of that law in practice. Now, it's tempting. While I want to balance a little bit what the regulator has said, if there are any lawyers here, or new or aspiring lawyers in this room, don't be scared or frightened by the strong powers of regulators and other bodies within the AFC. Those powers exist for very good reasons, which you've heard about, but ultimately the AFC Court has jurisdiction, among other things, to consider appeals or attempted appeals on any decisions of any AFC body, and that includes against the lawyers representing clients or whatever within AFC practice. We haven't had, I think, any cases along that lines yet. And it might come soon. Just a quick observation about some of the practices that we've seen, and I'll share this on a personal basis. I'm not going to say this on behalf of the court or arbitration centre, and I say it as someone who's very fortunate to sit with a brilliant young case management team, all Kazakh, top international standards, by the way, on the registrar's bench in every court case. I've been in every single case since we started, and the court's now given 200 judgments, and there are quite a few other judgments on their way very, very soon. When we first started, and we have to bear in mind this project, the entire AFC was nothing but a blank piece of paper. We wanted, and I say we, I mean Lord Wolfe, former Lord Chief Justice from England, the person who created the court and the arbitration centre with the support of the AFC, and to a very limited extent myself and others. The standards have massively improved. So one of the, I wouldn't say it was a fear, but one of the questions we used to get repeatedly from 2017, 2018, the very beginning of this project, was, I'm a Kazakh lawyer, can I use this court? Can I represent my clients in this court, in this arbitration centre? And the answer from us was absolutely yes. This court does not exist to service the legal industry or people of Kazakhstan or anywhere else. It's for everybody. And one of the concerns from some of the senior Kazakh lawyers, and some of them are in this room, that the English barristers and American lawyers and the Australians and other common lawyers, traditionally common lawyers, would dominate all of the opportunities to represent clients. That simply hasn't happened. I had a court worked at a court for some years in Qatar before coming here, and that was not necessarily the case. I think the balance was probably about 50-50 between Qatari nationals, lawyers, and international counsel, chiefly barristers from London sets of commercial chambers. And what we've noticed here is that I would say 90% or so of the lawyers representing businesses, investors in Kazakhstan, in our court and arbitration centre, are actually Kazakh lawyers. Some of those lawyers have been lawyers for many, many years. And I'm not going to look at anyone in particular in case I upset anybody. But what has been an interesting trend in the last 2 to 3 years, in my experience, has been the growth of young Kazakh lawyers coming through. People who have, and we know because we work with the universities, who have been young law graduates, who have taken on the training programs that the Academy of Law and also our AFC Court and IC Training Centre, which is a completely separate training centre specifically for dispute resolution focus and preparation for representation by lawyers in court, the court and arbitration centre proceedings, has had to play. So a couple of things which were prevalent in the early days, which are happening less and less now, because what has happened is, we all know Kazakhstan has a brilliant education system. It has a brilliant system of boards, of bar associations, but those are private. They're not managed by the state, and there's no, I would say, state initiative to train and develop the lawyers in a similar way that you would get with a year or 2 years professional training, in addition to training on the job effectively as a barrister or solicitor in England and Wales. So we've come to a country with a different way of doing things. And what we have contributed through judicial practice, in addition to a lot of training programs, including on common law advocacy in particular, through our training centre, led by some of the world's most foremost international law firms, the biggest reputations. Our judges are absolutely robustly independent and impartial. Nobody has any authority or any even slight possibility of encouraging or telling them what to do. They'll make up their own minds, and their entire careers as some of the most distinguished judges from the English legal system, but recognised globally for their expertise. Nobody's going to be able to question that. That is absolutely guaranteed, and I want everybody to take that away. But what the judges have been doing is equally explaining to the counsel in our cases what they're asking them to do and why they're asking them to do it. And what that has done is help, I would say, between 5 and 10, now very senior Kazakh lawyers in particular, really learn from practical experience in the court. All lawyers, all advocates, if they hopefully have professional training, if that's required by their jurisdiction, but they all learn on the job, ultimately, and that's why they become more experienced, get better clients, and all the rest of it. So our judges have played, I think, a pivotal role in not only developing the jurisprudence, of course, of the court through its decisions, but by assisting in independent capacity, and that means assisting everybody in a hearing, by explaining what it is that they're asking them to do and why. So that has assisted the lawyers to move forward. It's also enabled more efficient proceedings, reduced costs, and all the rest of it for investors. Some little things which used to happen quite frequently, which do not happen now, but to give an idea of the history and the maturity of this court through its lawyers' practice. Misleading statements, judges ordering parties to file particular reports, and then the party not doing so, parties just suddenly being on holiday and thinking the whole court proceedings would be shut down and we wouldn't have to face justice. Finally filing the report, but making sure it's the wrong report in the hope the judge wouldn't bother to read it over lunch. Making endless interlocutory or pre-hearing applications to the point which could possibly be considered to be leading towards a vexatious. Applying pressure on other counsel in a really inappropriate way, simply refusing to comply with case management directions and orders. These things happen in courts all around the world. It's not just Kazakhstan, it's everywhere, but it seems to have been cut out to a large extent now. And that, for me, has been because of the strong decisions and the directions that our judges have taken. They haven't been bothered or budged by anybody, as we'd all expect, for absolutely world-class international independent judges of the highest repute. To back that up, though, I've mentioned the training centre. I'm not going to say much more about that. There is a website. It speaks for itself. Some of the people I recognise in this room have done some of the training. There will be an international law firm, common law advocacy training session soon. I encourage everybody who's a lawyer, or if you're business people, to encourage your lawyers to sign up for it. It will be invaluable, even if you don't intend to be a lawyer, just to learn more about how court practices work. But we actually regulate, to some extent, I would say at this stage in a very light touch fashion, the conduct of all lawyers in our court. If you want to be a lawyer representing a client in our court, not the arbitration centre, but in the court, you have to comply. Firstly, you have to apply for rights of audience, and it's ultimately awarded by myself as registrar, and that's normal practice for our type of international financial centre court. If you're a Kazakh lawyer, or you're a lawyer who has practiced law for some years, you've got an undergraduate law degree, you have some proven experience of representing as an advocate in a court, and we say for two cases by minimum, as mentioned in the judgment, typically at the end of a judgment as counsel for a party in that case, then we will consider you for rights of audience. And it's a very open, there's no fee involved. You do have to comply with a code of conduct, which is on the website, and the code of conduct is very strict. The code of conduct complies with our rules. It requires all counsel to comply with the overriding objective of the court. And very quickly, it can be found on our website in the rules. The overriding objective essentially requires everybody, the court itself, but also counsel to observe this, to deal with cases justly, ensuring the system of justice at our court is accessible and fair, all parties are treated absolutely equally, nobody is ever favoured, and deal with cases expeditiously. There are other requirements as well, but I mention that because if you take away one thing in terms of discipline as a lawyer in our court, you must comply with that overriding objective. In addition, under the Code of Conduct, you must act as a lawyer, that means representing somebody for payment, with independence, integrity and civility. You must comply with your duties to the court and to the practitioners. This is often something that's confused. As a lawyer here, as an advocate, you have a duty to assist the court. You don't just have a duty to your client and to do whatever you can, including misleading the court to try and win the case. You have to act with absolute integrity and civility. You have to act in the best interest of your clients, of course, but subject to what I've just said. You must keep confidential the affairs of your clients. That's something which is frequently not represented all around the world, but also here. And you must maintain proper standards of professional practice. You must uphold the rule of law, and it helps if you understand what the rule of law means and requires in the first place, which we work towards through our training centre for some lawyers, particularly the younger lawyers coming through the system. And you must enhance the honour, integrity and the dignity of the legal profession. So you're not just there to represent your clients, you're there representing the entire legal profession and to some extent to the court in the sense of trying to assist it to come to a fair, independent, impartial decision. Justice is the most important factor here. It's not just a question of winning or losing. If lawyers don't do that, then anybody has a right to apply to the court under the Code of Conduct for sanctions. And that could be a private warning, it could be a chat between me as registrar, and that's happened a couple of times already. Just simple informal discussion about what happened in the court, why did it happen, and let's make sure that doesn't happen again. If it goes further than that, it can go to a judge of the court, and under the code, lawyers can be publicly warned. They could be on the website, and they could be withdrawn temporarily from having rights of audience in the court or permanently. Now, none of that has been utilised yet, and we will be revising the Code of Conduct in the coming months to make sure it's even more robust. But the ultimate position there is that this is in place to protect the integrity of the court, the judicial system and the arbitration system of Kazakhstan, of the legal profession using the court and arbitration centre at the AFC, and for justice ultimately, because we're all trying to arrive at truly independent, impartial justice. I'll leave you on this point, and that is the standards have massively improved. One of our now retired judges at the AFC courts was on the record as saying that in his experience, and he did quite a few cases on his own as a single judge, the standards were comparable to some lawyers in London, some of the best advocates in London, and that was a very, very senior distinguished judge with profound expertise and competence and knows these things better than anybody. So I commend what's happening at our court by the Kazakh legal community. We encourage everybody to consider training as a lawyer with us, with other people, including the Academy of Law and the universities and so forth, and international training providers, and to use us. Come and use our court. It's there, and our arbitration centre is there for everybody. Thank you.
Thank you, Chris. Prior to moving to Maxim, let me ask the audience how many registered legal advisors we have here. Can you please raise your hands? Oh, not so much. Who has the right of audience in the AFC court? Okay. Good. So finally, it's important to hear from those practicing under AIFC law. Maxim, let me turn to you. As someone on the ground delivering legal services within the AIFC and having previously served as a member of the AIFC Legal Services Board, how have these requirements impacted to your firm's operations and a wider legal market, and what benefits or challenges do you see for lawyers or clients being a part of the regulated AFC framework?
Yep, thank you, Aida. First of all, like long story short, it impacted and affected basically the industry quite a lot. But I would say the changes are rather evolutionary than revolutionary. So first of all, as you may probably know, in Kazakhstan for quite a long period of time, we did not have a very well established system of like similar standards, norms and approaches for legal services. There was one kind of exception for advocates who were licensed lawyers, and therefore they had to pass some particular exam. But I wouldn't say that the system of their rules and standards worked very well, and one may argue that maybe sometimes it maybe lacked some clarity or regulation and the mechanisms to like enforce those standards. And but then comes the AIFC, and it's a kind of a game changer for Kazakhstan, I believe. So it attracts the investors, and local business with tax incentives, with corporate flexibility, with stable judicial system, stable legal system, which I believe is a kind of new for the whole Kazakhstan in like this respect, because there were sometimes some kind of doubts in terms of local legal system, especially for foreign lawyers. And so logically, once the investor came to AFC, the lawyers followed, just basically to respond to the market demand. And I believe there was a market demand at that time. The lawyers needed clients, the lawyers needed to respond to clients' needs, so that was quite predictable. And at the first time, like from my personal experience, it rather maybe reminded me of some kind of Wild West exercise, I would say. Like lawyers interpreting the law as the previous panelists mentioned, in a very strange way, sometimes mixing it up with local law, trying to find some kind of shortcuts in terms of interpreting the law and coming to swift conclusions which already familiar to them. So those were the same lawyers who were working on mainland law, and they now try to practice AIFC law. But the problem was obviously that it's a different legal system, which means that many of the approaches they used to didn't work in this new system. So as to the standards which were introduced for legal community, basically, obviously, the market dictates the standards in terms of the competition, but those, I would say, highest standards of the industry, like this, assisting to the court, as Christopher mentioned, or being protective for the client, but in the best interest of justice. Those interests, I believe, they may take decades to crystallize in such kind of market generating the standards. So I believe now having those standards introduced into the legal system, at least for AIFC, is a huge step up, is a huge step forward, because it's kind of shortcutted the whole process of crystallizing those best standards. I believe they brought discipline for the lawyers, better approach, which it was usually practiced by the best law firms, top law firms in the country, mainly international law firms. But now those who practice law in AIFC had to follow those standards, which I believe is very good for the whole legal community. So answering to the question about how it impacted, how it affected the whole legal community, I believe the effect is very significant, and it's good, and it's a good change, but the road is still ahead, because as was previously mentioned, there are much to learn in terms of the standards, in terms of the application of the law, etc. So concerning the enforceability of those standards, I would also mention that in Kazakhstan, as you probably know, it is possible to claim some damages for bad services, legal services, etc. But in a local legal system, it is quite hard to prove that the legal services were conducted or rendered poorly. This is where also I believe those standards of AIFC comes to rescue, because in AIFC court, when basically it is substance over the form, I believe it is way simpler and more efficient to prove that the legal services were conducted in a poor way. So that is why those standards eventually come to work properly. And this is also a very positive change, I believe. Those standards we have are way higher, I believe, than those we have previously, but they discipline the lawyers, and this is also very good for market, for the whole market, and for Kazakhstani lawyers on, I would even be brave to say, international market for legal services. So for our practice, as myself as practitioner lawyer, I believe those standards did not have significant impact, because we basically, as one of the main law firms in Kazakhstan, we upheld quite high standards for ourselves. But nevertheless, it systemized and crystallized those standards we may have in mind, but didn't voice them for ourselves properly. So this is also quite a positive change for ourselves, as a law firm, I believe. So in terms of the challenges and opportunities for working in AIFC, which was also asked before, I believe those opportunities are huge, and the challenges basically were previously described in terms of training. But I believe going and joining this community and joining the AIFC practicing lawyers, it gives a law firm, an independent lawyer, quite huge possibilities to be of assistance for their client, to learn how to work with completely another legal system, to maybe even adopt some best practices, not only of the common law, but of the main financial centers in the world, like the AIFC, Qatar Financial Center. I believe the practices from those financial services were also adopted when, like, the gentleman drafted and created AIFC Law. So I believe enjoying and using this law, practicing this law is basically practicing the best practices we have as of today. So, and the work in this regulative sphere, it gives also its advantages. So, as you may probably know, it is necessary to get admitted, basically, to practice AIFC law, and this is also brings lots of opportunities in terms of being transparent and being trustworthy for your clients. Because once the clients see, especially those which are used to common law jurisdictions, once they see you are admitted to admitted to practice AIFC law, a common law system, they may have a bit more trust in you just because of this mere fact. And basically, coming to the conclusion, I believe we kind of used up our time. I would call everyone, independent lawyers, non-registered law firms, to join the community, to practice this system, because this is extremely interesting. This is something completely new, and this is a huge step up, I believe, for any lawyer in Kazakhstan practicing mainland law, to widen that lawyer's practice, widen that lawyer's expertise. Thank you.
Thank you, Maxim. Just would like to add that Grata International, one of the law firms who has great variety of transactions within the AIFC, from redomiciliation, from the first redomiciliation to M&A transactions, and last year they won legal award for the best law firm in the AIFC.
Thank you.
Thank you. So. Thank you to our panelists for sharing their perspectives, and to the audience for their attention. What we have heard today is clear that the AIFC law depends not only, the future of AIFC law depends not only on legislation, but also on the quality of those who practice it. Regulation of legal consultants, strong oversight, professional advocacy in dispute resolution are not abstract concepts. They are safeguards of businesses, investors, and reputation of the AIFC as a jurisdiction. If a consultant registered, they are regulated. If regulated, then they meet the standards. And when the standards are high, the clients can place their trust in the AIFC. This trust will bring the long-term investments, it will bring the companies, big companies, and interesting transactions. So my call to action is straightforward. AIFC participants and lawyers alike must prioritize engagement with registered legal consultants and registered law firms within the AIFC. This is how we ensure legal certainty, investor confidence, and the substantive development of the AIFC law. The better our standards, the stronger our financial center will be, and the stronger legal services we have, the AIFC will continue to grow as a trusted and leading financial hub in Eurasia. So thank you.